Okay, so this is just, something I want you guys to just read through it once. We can discuss it really quickly before we get back to the question. But what do they expect from you? Know the tests decided in the cases. Know the tests in the decided cases. So they're definitely talking, of course, about Street and Mountford, but they also want you to be aware of the additional discussions that were in AG Securities and Tenides. To some extent, Bruton, but that's not really a test as such, right? So to understand the salient facts in those cases, I always recommend reading the facts of the case, but for no chapter do I recommend it as much as I recommend it for leases. In leases, if you read the judgments of AG Securities and Antonides, you will have such an easy time preparing this chapter that you're going to wonder why you haven't been reading the judgments all along. The truth is because you guys don't have time, because you have so much to cover. And of course, you don't have lives outside of law. You guys are law students, right? So you don't have time, I understand, to read all of the judgments. But that being said, the most important judgments, they want you to know the facts of those cases, right? Let's say that you don't read the judgments, you can at least go on like Swarb or Bailey and read the summaries of the judgment. At the top of each full long judgment, there's like a brief sort of background on what was decided in the case. At least read that, right? So it says, candidates are poor at discussing the facts of the problem. I'm so sorry. In light of the facts of the decided case. They're saying, stop giving us general answers. Can you give us a specific response? Give me 1 second, guys. Sorry, guys. So what they're saying is use the facts in the problem question that we give you guys. Don't just tell us about, that was a fact. What was the fact? Sorry, what was the fact?
Mr. said we don't have a life outside of law.
Yes. Yeah. Oh, okay. Yeah. I thought you were saying that.
That is a fact.
Yeah. Yeah. So they want you to be talking about how is the example of Abe and B and Dot similar to the case of Antonides and Villiers. And sometimes it's so similar because they literally look at the case law and they're like, maybe we should turn that into a prop question. And then they do. So they expect you to be able to see that and say, oh, this prop question looks a lot like a case I read. And tell them, hey, I know what you guys are doing. You're basing this prop question or this part of this prop question off of this judgment. These facts are similar to these facts, right? So Era asked me a really good question. She said, should we have to write the entire case? Do we say that these are the facts of each case every time we're citing a principle? The answer is no. Most of the time that you're citing a principle, you're just going to mention the case name in brackets in passing. But for the very important cases, for those, yes, you will want to mention the facts. So if you know that they expect a discussion on Bruton or they expect a discussion on Antonides and AG Securities, then in that case, mention the facts. Tell them this was a couple that was living together and then one of them left. What was the similarity to the question at hand? Sometimes there have been leases questions where one party has just left. You're going to compare that. And then you're also going to draw a distinction. Maybe in the question that you have, you're going to say something like, oh, this wasn't a husband and wife. This was just like, friends or something like that, or so on and so forth. So my point is that's when they say candidates are poor at discussing facts of the problem in light of the facts of the decided cases, they want to hear a sentence like, Abe and B occupied the flat as a married couple, and therefore the court would probably be inclined towards interpreting this as a joint lease, as was done in the many cases, and then you can give whichever cases you think are the most relevant at that exact moment, right? And then what you'll say is the facts in that case were so similar because even in that case, Mr. Street and Mr. Mountford, or it wasn't actually, I don't think they're both Misters, but I forgot which one was which. I think it was Mrs. Villiers and Mr. Antonides, or so on and so forth. I'll check. But the point is, you should be able to tell them specifically who the individuals were, what they had claimed, and what the courts had agreed with or had not agreed. It was Mrs. Mountford. There we go. And Mr. Street. So yeah, so that being said, that's as much of that as you can insert into your problem question, the better. Like the more that you can say, this reminds me of a case, look how smart I am, right? Remember I told you guys last time, you don't tell people how smart you are. You show them. You don't tell them, dear examiner, I read this entire judgment because my annoying property law tutor kept insisting that I have to know the facts of this case, therefore I'm writing the facts of this case. No, you just say, oh, by the way, that's like this case I read, right? So for example, have you ever met those people who like, as soon as you meet them, they're like, oh, I love Dickens. I've read everything by Charles Dickens, or I don't know, whatever Tolstoy or boring authors are out there. Like they feel the need to tell you. And then you're always like, did you read them just so you could tell me that? Like, awkward. And when somebody just kind of, yes, exactly that being. So many, I like how you guys are reacting to this because you can relate. I can so relate. And then if you compare that to a situation where you're just talking to somebody and they're like, oh yeah, like, oh, ha, 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 like in that Dickens book. And you're like, oh, see, like you didn't have to shove it in my face. You just kind of mentioned it. And maybe you did that on purpose, but either way, it's not as obnoxious as somebody saying, well, I read this book. Did you read this book? It's my favorite book. It's nobody's favorite book. It's freaking boring. Anyway, no offense to you guys, but like, why would you read Oliver Twist when you can read Harry Potter instead? I'll do a separate YouTube video just about the books that I recommend for you guys. But anyway, the point was that show, don't tell, that you know the facts of these cases. Mention them in passing only when relevant, okay? Now, the next thing that they said was identify, a good problem answer follows the following pattern, right? So first identify the issue, then give them the law, and then notice. Right? I'm assuming you guys have read this because you don't need me to read it out loud to you. Third, what does this say? Vitally. Do you guys know what that word means? It means it's vital. Your vital signs are the signs that you must, the doctor must know in order to determine if you're lying. That's where vital signs comes from. It's not from the band. Like the band got it from that. I mean, just in case you guys were confused. I was confused. I remember when somebody said, oh, well, what are your vital signs? And I was like, what are my favorite songs from vital signs? And like, no, it was a very awkward conversation with a doctor. And I was like, oh my God, that's a thing? Anyway, so yes, it is a thing. So third, vitally, as in importantly, as in significantly, as in crucially, as in critically. There's no other way they can say this. This is really important. So vitally, it applies that law to the facts of the problem. I have said this so many times I've lost count. Apply whatever cases you have, whatever principles you know, to the facts in the problem question. Mention them by name, give the detail they mention, and it is a sure shot way of succeeding, of writing a good answer, not even just a passing answer, but a good answer. If you give me two questions, two answers, one in which the entire law is stated correctly and completely versus an incomplete, shorter answer that does not have every single principle correct, but applies those principles to the fact, I will pass that answer that applies the law to the facts, even if it's the incorrect law, and I will fail that answer that only gives me law and no application of law to facts. Why do I say this? Because that's what they say in these reports. They say it again and again. They say this is correct, but they did not apply the law to facts. Fail. Okay, great. Now that we have that out of the way, in doing this, you should discuss the relevant facts of the problem that would be important. So they don't want you to talk about, like, you know, why was Abe on holiday without B? You know, like what, like that ruined their entire lease relationship. Maybe they were never meant to be in a lease together. Like they don't want you to fixate on it. They want you to fixate on stuff like the term says occupation charge and not rent. Like we're not fooled, right? So you get my point. You can figure out what's relevant. God, I hope so. Don't fixate on stupid things, right? Why is it called clean ease? Is it easy to clean? No, like focus on what's important. Dot is B's mother. You want to mention that, okay? Fourthly, it must come to a conclusion. You guys know this. As a fifth element, ooh, this is the sprinkles on top. A good answer might consider any journal literature or other academic points, or dissenting judicial opinions. Actually, this is what I would put as most important, relevant to that issue, which suggests that the law is optimal or suboptimal in the context of the problem. What do I always tell you guys? What do I always say? They want to talk about what's controversial. They want to spend time discussing the drama of property law. What is the drama of property law? Bruin is basically like the, that episode where you're like, oh, like how did they even get away with this? Like the main character gets shot and then everybody rushes to the hospital and they put him in the ground and then he climbs out of the grave. Like that is like next level drama. That's exactly what Bruin was like. So they want you to discuss when they say optimal or suboptimal, where can this be improved? So I can move on to you guys. Sorry about that, guys. Anyway, so yes. So as I was saying, where the law is optimal or suboptimal, essentially that's their way of saying, tell us how you think this could be better. Would you suggest reforms? What would be, sorry guys. Yes, Hoffman would definitely be the lead role. Property law is very exciting drama. I don't know who's calling it dry, but like, yes, you should keep everything relevant and to the facts. Lord Hoffman, definitely. Lord Denning, is he the villain or is he the superhero, guys? Yeah, I think this is a great, you guys have like a really great like eye for drama. So maybe we could come up with some sort of a stage play. Lord Denning, definitely going to be superhero or villain. Who knows? Anyway, so the point is, talk about that drama. They are human beings just like us. And they love drama as much as the next Pakistani, even if they're not Pakistani. Like we learn everything we learn from them, right? Like we like give us the tea, that's what they're saying. That's what the kids these days are saying, right? Please tell me that's what the kids these days are saying. Because sometimes by the time I learn what the kids these days are saying, they're adults. So anyway, give them the tea, okay? They're Kermit sitting there waiting. Anyway, so this is your structure. It's not even, you don't even need to worry about IRAC as much as you need to worry about what is written right here for problem questions. Law, fact, issue, law, application of fact, right? And that's why I say general, specific. When I say general and specific, that's basically my way of saying the general law, and specific is applying it to the facts at hand, okay? Now, this is the real reason I opened this document. That was just a bonus, but the real reason I opened this document is because I wanted you guys to see these cases, take a real quick screenshot just so that you guys can come back and remember that these are the cases which, in my experience, came up the most when I was going through all of these past paper questions. There are, of course, more cases than just these ones, but these are the ones which, like, every single year you'll see they're mentioned, right? Beresford and Maxfield. Why is this not here? It should be here. Add Beresford and Maxfield in there. Yeah, but these are the majority of the cases. This is not an exhaustive list by any means. Please, please, please yeah, I agree that the tea is very cold and bland, but it's British after all. They don't put masala jai like we do. So Michaelver and Brady, Street, Mountford, AG Securities, Antonides, and Villiers, these are the ones that are mentioned every single year. Aslan and Murphy is not like a huge case in property laws. When you read Dixon, you're gonna be like, these aren't even that important. But the reason that I put that in there is because it becomes really relevant to the clauses that talk about somebody coming and living on the couch or somebody coming and entering at any time that they want. Because in Aslan and Murphy, they were trying to figure out if in reality the clause was a sham device or could just be, or would have actually been used by the parties. So there was, I'm just gonna switch screens now, back to that, if you guys have all taken the screenshot. But the reason that I say Aslan and Murphy is really relevant is because there was one year that there was a question and it said something like the landowner can come at any time and he can sleep in the flat, or he can crash on the couch or something like that. And what the facts were was that there was not even enough space, or there wasn't even a couch, or the only place he could have crashed was the couch, or there was a 1-bedroom apartment. So it's not like he was realistically going to get into bed with a married couple, right? That would just be creepy, illegal, I'm sure. So the point was that he put that in as a sham device to make it look like they didn't have exclusive possession, but in reality, he was giving a 1-bedroom apartment to a married couple. He had no intention of ever living in there with them. Okay. I'm just gonna go back to sharing it. I assume you guys want me to share that question again, and here we are. All right. Now, what is the detailed answer for this? You guys are welcome to give me your opinion. Oh, actually, since I have the report for this, I'm gonna put that up instead, if that's okay with you guys. I don't like usually doing this because I don't like just handing you guys questions, but since it's our last day together, yay, I mean, I'm gonna put this up there just so that you guys can see how I use these reports to interpret what you should do for next time. I'm also sad. You guys have been a great batch. Let me just put that out there. I hope nobody from my last batch ever watches this, but you guys are so much better. Like, don't tell your friends. They know though, I told them, I think last year, I was like, not my fave, guys. Okay, no goodbyes yet. Don't make me cry. Maybe I'll come to your examination center. Oh no, you guys don't do that anymore. Otherwise I would. Anyway, so this is the way that I follow these reports, right? So you can, don't skip this, but it gives, very general information. Always, this is where I got my list from. Always, always, always check which cases are important. It's the same ones that I mostly put in your list. And then the common errors are almost always going to be the same. It's going to say that people did something really stupid, like they didn't realize this was a LEASES question, or they didn't apply the law to the facts. This is where you're going to get the good stuff. This is where they're going to tell you not just what they think, because the answer is it's not important what they think the answer is, right? It's important what they want you to discuss, right? And this is where you'll see that the very first thing that they mention is consider and apply, of course, the ideas of Lord Templeman, but in addition, as the occupiers are a couple. So you know that this is going to be what they want you to focus on. It will be necessary to give advice on whether or not A and B are joint tenants. If they're mentioning a case twice, double highlight it. Make sure you go back and read it. Antonides and Villiers. In doing this, candidates are expected to draw on relevant judicial approaches to argue about the impact of the various terms of the agreement that deal with labeling, cleaning, retention of keys, the different signing dates, and the need for them to be each to be liable for the entire rent. Okay, does this sound familiar? If you took a screenshot, then it will, because this is exactly what we were talking about with, this is exactly what I wrote next to Mike over in Brady, right? It was, I think the guy left or the girl left, and the other person would have had to pay the entire sum, or they were expected to pay the entire sum, right? So you won't be able to draw on relevant judicial approaches if you don't know what the relevant judicial approaches are. In order to know what the relevant judicial approaches are, you've got to at least skim read these judgments. Like you have to. Not to mention when you guys graduate and you go to like a law firm, they're gonna be like, oh, read this judgment. And I've seen this where interns are like, how do you read this judgment? And it's like, first of all, start at the top. with the title, right? If you've never read a judgment before, it can be very intimidating. But once you read 2 or 3, then you get the hang of the way that they're written, the language that they use, and the flow and the structure of a judgment. And then it'll make your life next year a lot easier for like trust law and for jurists, right? So anyway, to argue about these terms, and now they're telling you which terms, this you already know, the label being calling it an occupation charge, cleanies being able to come in, retention of keys and the different signing dates, and so on and so forth. And then outside the terms of the agreement, other factors that merit consideration are the lack of cleaning devices. This is exactly what we were just discussing about Aslan and Murphy. Is it actually, is there any intention to actually ever use this, or is it just their way of throwing you off? Family relationship between B and D, and the fact that she only has a license. What did I tell you? They want to focus on Bruin. Promise, I didn't read this before, but like I've read it at some point in my life. But like just get into the habit. The more that you read the prop questions and circle what's relevant, and you start to read the reports thoughts on, the more these things will pop out at you. Exclusive possession aside, a further obstacle to finding a lease is whether Clause A establishes a term, the maximum duration of which is sufficiently certain in the prudential sense. You can just refer to it as prudential. You don't even need to really write prudential in LRB, but no harm. So is it sufficiently certain for this to become reinterpreted as a lease that can be converted into a lease of 90 years, right? This, let's just read it together, I guess, establishes a term, the maximum duration of which is sufficiently certain in the prudential sense. You won't know what the prudential sense is unless you read the judgment, or you read, I'm just gonna tell you which page it is. In my book, it's page 226. It's a really good explanation. The last paragraph is actually the best explanation. So the entire chapter, the entire section is only 3 paragraphs, but the last paragraph of the certainty of term subsection is the most important one. It's what talks about the prudential type of sleight of hand, right? So, if the clause is interpreted to create a term of 5 years or more, could Mexfield and section 149.6 of the LPA be applied, or is the notion of a terminable maximum duration of 90 years incompatible with facts in which Dot's interest will have expired long before? So this was like a bit of a curveball. I actually think that it's really interesting. What they decided to do here was they were trying to put a maximum on the person granting the lease. So the maximum was the 40 years, right? So what they want to know is, are you aware of the fact that 40 years might clash with reinterpretation of the uncertain term? If this had not, that bit about Dot only having a license of 40 years is going to make you want to reconsider. So what they'll do, by the way, is every couple of years they'll give some sort of a new aspect to the problem to make sure you're not relying on rote learned answers. So something like this, Dot having a 40-year license, is something you might not have been able to predict in looking at the years before this. So they want you, so be ready for some sort of a twist. This was the twist in this situation. And what they said is perhaps the answer is that it is a determinable 90-year lease that will determine on the tenant's death or Dot needing the flat for her own occupation, or when her interest comes to an end. So what they're saying is maybe the termination of the lease is not going to be when Dot needs it back, but it's going to be the end of 40 years if she never needs it back, right? Or when her interest comes to an end. That's going to be her 40 years, her 40-year license completing, right? As the agreement provides for payment, any advice to the effect that rent is a usual rather than required element of a lease can be brief. See? Very minor thing they just want you to spend not even 10% on. Similarly, as it does not matter much to the status of A and B's agreement with D, there's no call for extensive consideration of the differing formalities required for a legal, is the document a deed, rather than an equitable lease. See how they're telling you here, we don't care if it's legal or equitable. We did not specify in the question because of the fact that we're just trying to figure out, is it even a lease, right? So you don't need to waste time just telling them the whole chapter. You just need to tell them, I know what you want me to discuss according to these facts, okay? Poor answers to this question evidence a lack of sensible planning Always plan your answers. Take 10 minutes, take 15 if you have to. Circle the things that are important. Write down the order that you guys are going to go in. Oh, sorry, I just realized that you guys are sending chats. Aw, you guys are so cute. Aw, I'm your fave. That's so cute. Don't make me cry. And had often taken insufficient time to think through the issues raised by the various clauses in the agreement. So what they're saying is people were just kind of bulldozing through. They started answering the question before, they started writing down their answer to the question before actually organizing their answer to the question. Always, always, always organize your answer to the question. This is a classic example of the order in which you should proceed. I think that it's relatively straightforward what conclusions you guys can come to. I personally would say that this is actually the type of situation where it is going to be difficult to prove that it's a lease just because of the lack of the unity of time. The certainty of term is questionable. On top of everything else, Dot had a license. And in Bruton, if you guys remember, there was this element of how the trust had to do repairs and that sort of a thing. And that was a type of a covenant that they said you usually only see in leases. You don't really see in licenses. Now, you won't know that unless you read this section in depth and unless you read the judgment in depth. So make sure you guys do that for all of the important cases for this chapter. The same goes for the important cases in easements, mortgages, and adverse possession. Now, of course, all of the chapters in general, but these I find are always going to be the most straightforward. They almost always follow the same formula, and they always have just three major cases that you guys need to focus on. I've got to actually, I've got to go. I'm so sorry, but this was, I think that's the perfect length of time. But I just wanted to say thank you for being such a great group this year. If you guys have questions, you guys can, is it safe to do an essay on mortgages? Yes, absolutely. Mohammed, who asked a question, the answer to whether you can give a lease if you have a license is in Bruton. It's on page 226 of my book, which is probably back and forth of yours. Sajal, you have a question? You're very, very welcome, all of you guys. Thank you, Daveen and Samra and Sabah. You guys are really sweet. Yes, you can send it to me on Gmail. If I take time in responding, and I know I do, I'm really sorry. It's just been, you know, this huge arbitration at work. So I'm really sorry about that, guys, but I will do my best. You can feel free to send me follow-up emails. You can, oh, that's very sweet. You can pester me as much as you want. Just please don't call me like incessantly. Like that's one thing that I can't. That's very cute. I take a lot of sugar in my tea, like 4 spoons. Not in my coffee though. But anyway, you guys have been really great, and hopefully I'll see you all soon. When you guys graduate, if you need internships, hit me up, and I would love to see you guys again. And have a great year. And good luck. I will try to make a cheesecake video. Good luck on your exams, and I will be in touch if you guys have any questions. Right. Take care, guys. Allah Hafiz.
Thank you, Miss.
You're very welcome. Allah Hafiz.